Good afternoon, everybody. This is Brian Koji with Allen Norton & Blue. We're going to get started on today's webinar. Today's webinar is entitled Regulatory Changes to Wage and Hour Law and Strategies on How to Efficiently Respond to Them. Many of you know who I am, but for those who don't, I'm a partner in the Tampa office of Allen Norton & Blue. Today's webinar is probably, as many of you know, very timely. As I was preparing for today's webinar this week, we were preparing based off of the proposed rule that the Department of Labor issued regarding minimum salary for exempt employees that was issued last July. And we anticipated that the Department of Labor was going to issue the final rule any day now. And lo and behold, they issued it this morning at 8:45 a.m. So I've been working diligently since then to update the PowerPoint and come up with any changes. There were a few changes from the proposed rule last year to the final rule that will go into effect this year, and we'll cover those as we move forward. I am, as I said, a partner with Allen Norton & Blue's Tampa office. If you have questions today or you need guidance on these changes, you can certainly feel free to contact me. I'll have the contact information at the end of the webinar. You can also feel free to contact any attorney in Allen Norton & Blue's 4 offices. Many of you know we have offices in Coral Gables, in Orlando, Tampa, and Tallahassee. All of the attorneys are familiar with the final rule that was just released and can provide guidance to you. The changes that the final rule makes will definitely impact most employers. Any of you who have exempt employees under the white-collar exemptions from overtime are likely to be affected. The changes will substantially increase the minimum salary requirements. It's going to be recalculated on a periodic basis so that these changes are not one-time changes but will be continuing to change in the future. And importantly, while the revised final rule was announced this morning and it will be published in the Federal Register next week, the changes themselves do not go into effect until December 1 of this year. Again, that's December 1 of this year, so everything that we're talking about goes into effect in about 6 months' time. Now, that does not mean that you should forget about it until then. As you'll see from today's webinar, you should begin things as early as today as to how you react to these changes and prepare for them. Before we get to the changes, I want to briefly review the white-collar exemptions themselves. For those of you that are not familiar with, the white-collar exemptions are exemptions built into the overtime law that exempt certain employees from payment of overtime. Non-exempt employees have to be paid time and a half, typically, whenever they work more than 40 hours in a given work week. If you can meet one of these exemptions, that doesn't apply to you. In addition to the minimum salary that must be paid for these white-collar exemptions, you also must meet a job duties test. Typically, we refer to these white-collar exemption tests as the executive, the high-level administrative, and the professional exemption. To be an exempt executive, the employee's primary job duties must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise and supervising at least 2 or more full-time employees or the equivalent of 2 full-time employees. The employee generally has to have hiring and firing authority or effective recommendations in that regard. The high-level administrative employee, to satisfy the job duties test, you have to have a primary duty that includes the exercise of discretion and independent judgment with respect to matters of significance. So these are things like your human resources director, your finance director, those sort of things. It's not an exemption for low-level administrative or secretarial employees. To satisfy the job duties for the professional employees, you generally have to have advanced, something that requires advanced knowledge or degree beyond the 4-year bachelor's degree, or be involved in a career professional field, music, theater, that kind of thing. The current minimum salary for those white-collar exemptions is $455 per week. That equates to, for a full-time employee, to $23,660 annually. That amount was set in 2004, the last time the regulation was revised. You'll also hear a little bit of discussion today about highly compensated employee exemptions, and what that is sort of a shortcut exemption for employees that currently make $100,000 or more. The white-collar job duties exemption test is relaxed a little bit. So you do have to have a minimum salary of $100,000, but as long as one of your primary duties consists of doing the exempt duties of an administrator, professional executive, then you can claim the exemption without having to satisfy the rest of it. Before we get to the changes, one other thing of note, and that is that those job duties components that I just summarized are not being changed by the current rule that was just announced by the Department of Labor this morning. I repeat that the job duties component is not being changed. So what does that mean? That means while the minimum salary threshold is changing, to be exempt you still must meet all of the required primary job duties that we just covered. So now let's move and let's talk about the actual changes that are being imposed by the Department of Labor. The salary increase, of course, is the centerpiece of this revised regulation. As I said, the current minimum salary is $455 per week, or $23,660 per year for the white-collar exemptions. Well, the final rule changes that to essentially just a little bit more than double. Now, as of December 1, 2016, the minimum salary is going to be $913 per week, or if you equate that to an annual full-time employee, that's $47,476 per year. Now, this is a slight change, albeit a welcome change, from the initial proposal that was released last year. The proposed regulation pegged the 2016 minimum salary as $50,440. So we got a little bit of a discount here from the Department of Labor. The actual effective minimum salary as of December 1 is only $47,476. So that's a little bit of a change, and there was some compromise there by the Department of Labor. Now for the highly compensated employee, again, current until December 1 is $100,000 minimum. That has been changed to $134,004. So that has increased fairly dramatically from 100 to 134,000. Now to calculate these, what the Department of Labor did with regard to the highly compensated employees, they pegged this amount at the 90th percentile of all full-time salaried workers. In other words, if you make $134,000, then you're at the 90th percentile of all salaried workers in the United States. For the minimum salary of $913 per week, it's pegged to the 40th percentile. Interestingly, or at least I found interesting, the Department of Labor in their proposed regulation did not include a projected amount for the highly compensated employee as they did with the non-highly compensated employee exemption. But they did include an amount for 2013, which was $122,148. So I think that's interesting because it shows that from the 2013 calculation of $122,000 to the 2016 calculation, the amount went up roughly $12,000. So in the 3-year time frame, it would have been $122,000 in 2013. It's now going to be $134,000. Not sure if that will continue as this thing gets updated, but I found that interesting that rate of increase over a 3-year span. If there's a similar rate of increase for the non-highly compensated employee, I think that could be telling as to what you may see in the future. All right, so I mentioned that this will be updated. So while you have $913 required per week as of December 1, 2016, the Department of Labor, the new regulation provides that it must be updated every 3 years. Beginning on January 1, 2020, they will do this exercise again. They will peg it to the 40th percentile. They're going to use the lowest wage census region as published by the Federal Government's Bureau of Labor Statistics, and you will see an update on January 1, 2020 to these minimum salary levels. It's going to be done at the 40th percentile for the white-collar exemptions and the 90th percentile for the highly compensated employee exemption. Now this is a little bit of a change also from the proposed regulation. The initial proposed regulation provided that this would be done annually. In other words, the Department of Labor is going to do this every year, and it was going to change every year with inflation. Now it's only going to be done every 3 years. The Department of Labor has announced that it's done to allow more of a transition from one year to the next, so you're not having to adjust this every time. Of course, if inflation is rampant, then that 3-year jump is going to encompass all of the inflationary effects from the 3-year period, and it may be a bigger jump. Interestingly, these automatic annual salary updates, this is new under the Department of Labor's regulations this go around. They previously proposed this in 1970 and in 2004, the last time the rules were updated, but the Department of Labor did not follow through and actually implement it as part of the final rule. Well, this time's different. It is part of the regular final rule, and it is going to be no doubt subject to challenge by employer groups in the courts, but quite frankly, I think we're going to be stuck with it. I don't see the challenges being successful. It's possible, but I'd be a little surprised. So I think this aspect of the rule where there's this automatic COLA built in every 3 years is frankly here to stay. It was one of the centerpieces of this rule change, and this, according to the Department of Labor, will prevent the need to come back and revise these regulations every 5 to 10 years as they have in the past. Now, in the revised rule released this morning, one of the things that is a benefit to employers is for the first time you're now allowed to use certain non-discretionary bonuses and incentive payments, which include things like commissions or any kind of bonuses tied to productivity, profitability, those sort of things. As long as they're non-discretionary, you can now count those payments towards the minimum salary. That's new. Previously, you could not do this except for the highly compensated employee. Well, now you can do it for all white-collar exempt employees. Now, there are some limitations. You can only count it towards 10% of the minimum weekly salary. So if you have $913 current minimum salary as of December 1, you can pay essentially $91 towards that amount in a bonus, a commission, or any other type of incentive payment. To be counted toward this minimum salary, however, you also have to pay it at least on a quarterly basis, if not more frequent. So you can't wait to the end of the year and make a commission payment or a bonus payment. If you want to take advantage of this feature, you have to pay at least quarterly. Now, in any given quarter, if you're basing 10% of the minimum salary on, say, a commission, and you're not sure whether it's going to satisfy the minimum salary, whether he or she's going to earn 10%, in other words, the regulations do provide that at the end of the 13-week quarter, if your salary is below the minimum required because they didn't earn enough bonus or commission, then on that very next pay period after the quarter, you can make a supplemental payment to bring them up to the minimum. Of course, if you do that, you cannot use the supplement and count it towards the next quarter's minimum $913 per week. So that's something new, and it is a little bit of a nod to the employer groups, many of whom advocated for that. So if you do have incentive payments, you do use commissions, recognize that you will now be able to count them towards the salary up to 10% of that minimum requirement. Well, let's talk about the impact of these changes before we get to how to deal with the changes. The impact of the changes by the DOL's own estimates, this is going to convert 4.2 million exempt employees into non-exempt employees for overtime compensation purposes. They ballpark that 313,000 of those employees will be in Florida, which is, as you would expect, the third highest state, essentially due to population size and workforce size. They estimate that the rule change will result in direct employer costs between $239.6 million and $255.3 million per year. When you include all indirect transfers and costs, that dramatically increases to $1.18 billion per year, or up to $1.27 billion per year. So obviously this is meant to have a dramatic impact on employer-employee compensation. which I think is quite frankly part of the drive to implement these changes to begin with. So what should we do now? First off, as I mentioned several times, this does not become effective until December 1 of 2016. But if you take nothing else from today's webinar, please do not wait until November or December to start to take action. There are some things you should start to do now if you're not already doing them, and there are some opportunities that you're going to have now. Right now is the time when you should be reviewing all of your wage and hour practices, particularly with respect to these exemptions, and preparing to comply with the new change, deciding who's going to remain exempt, who might need salary adjustments, who's going to be converted to non-exempt, and how you're going to convert them to non-exempt. You also, I think, want to take this opportunity to ensure you're complying with other rules that aren't being changed, like the job duties test, like things such as timekeeping for non-exempt employees. Are you doing your overtime calculations correctly? Are you doing things like making automatic deductions for meal breaks through your accounting or payroll software? Those kinds of things, even when legal, expose you to potential liability. And so as you take this time to review the minimum required salary for exempt employees, we would encourage you to take that same time to review other aspects of wage and hour law, even if they're not changed by this regulation. And it makes sense, because if you're doing anything wrong in Florida, we're seeing wage and hour lawsuits every day. It's dramatically increasing, has been for the last 7, 8, 10 years. And right now, if you have to make a change because something's either done improperly or it's done correctly but in a manner that exposes you to a potential claim, you have a ready-made excuse, if you will. When changes have to be implemented and employees ask questions, we can point to the current required changes as part of the reason for the audit and subsequent changes made by employers. Now, I'm going to spend the rest of this webinar talking about the options that you have available for addressing any currently exempt employee that is earning less than your new minimum salary, or maybe even those that are earning slightly above it who could be dragged into this change in years going forward due to the COLA element. I've summarized on the slide before you that there are essentially seven options that you have, some of which overlap and some of which may not be applicable to every employee or every employer. And we're going to go through these in detail for the remainder of the webinar, but let me summarize them now. The first, of course, the one that the Department of Labor and the federal government would love for you to do is to take every employee who's currently exempt and earning less than $913 per week and simply give them a raise. Raise it to $913 or higher and maintain that exemption. Well, that may be a permissible and recommended action for somebody making close to that amount already. If you have employees making towards the minimum at $455 per week, for example, then you're essentially doubling their salary. So it's not going to be a practical solution for many of the employees swept into the purview of this new rule. So number two option, and the rest of these really involve how you convert currently exempt employees to non-exempt employees. But number two would be to maintain the employee's current salary level and pay overtime at time and a half. So this is probably the Department of Labor's second preferred things. Just start paying overtime. Again, Department of Labor estimates that in Florida alone you're going to have 331,000 employees that are converted from exempt to non-exempt. This is how they'd like you to do it. Just keep their salary the same. Start paying time and a half for all hours worked over 40. You can pay a non-exempt employee a salary, and you don't have to convert them to hourly. In other words, you can pay them a salary, but paying a salary does not get you out from under the overtime compensation requirement. So you'd have to supplement a non-exempt employee's salary with additional overtime compensation to the extent they ever work over 40 hours. So option number three is to convert the employee to non-exempt status, but make scheduling changes or other operational changes to limit the employee's hours to 40 or less. So this employee would be entitled to overtime, but the hope is that they would never need to work the overtime. This is more of an operational change, and I suspect it's going to be one of the first reactions that most employers will have to employees that are swept within the purview of this rule. However, it may not be the most practical solution if you have employees engaged in job duties where they've been traditionally working well in excess of 40 in a week. It's going to be difficult to take those employees and simply limit them to 40 hours or less. The fourth option would be to convert the employee to non-exempt status, but you adjust the rate of pay of the employee, the base pay, downward, such that when you combine the anticipated overtime that they work, it's going to be approximately the same as their current salary. This is the option that a lot of employers are likely to take and probably should take, but it's also the one that requires the most delicate interaction with your employees, as employees will no doubt see that as a demotion even if it's not meant to be. And I'll talk a little further about how to carry out this option to try and minimize that effect. Interestingly, if you go to the Department of Labor's website, and they do have some pretty good materials on their website this morning about these new changes, but if you go to the overtime rule change page, you will find right there on their page a shorthand list of what employers can do to respond to the changes, and they conveniently leave out this option number 4, adjusting employees' rate of pay, because they know it means adjusting it the base rate downward. They do, however, in the fine print of some of their other employer guidance on that page, recognize that this is a viable and legal option. So they definitely do not want you to do it, but they cannot prevent you from doing that. So you may hear some commentators, particularly over the next couple of weeks and right around December 1st, assert that employers are not allowed to lower base pay or base salary in response to this regulation, and they typically will contend it's retaliatory. You can ignore that. That's just flat out wrong, and typically those that are expressing that view have an agenda. You can make a one-time adjustment to an employee's salary or hourly wage rate, no different from promoting employees. You can reduce a wage rate and do it lawfully. Not to say it won't have some consequences in terms of employee morale and things of that nature that need to be considered, but legally you can do so. What you cannot do is you cannot manipulate the wage rate on an ongoing basis each week or each pay period to try and overcome the overtime compensation requirements. But you can do it on a periodic basis. One-time lowering of the wage rate is legal. So number 5, what's another way you can change a currently exempt employee into a non-exempt employee? Well, you can pay a salary based on the employee's normal schedule. So you can set up a salary to be paid with the assumption that it's worth 50 hours instead of 40 hours. We'll talk about how you do that, and we'll go through an example of a calculation momentarily. By the same token, number 6 is very related to that, but it's just simply converting an employee to a non-exempt status, paying them overtime, but you pay the overtime based on a fixed salary for a fluctuating work week. This is for employees who don't typically work a set schedule, and it tends to fluctuate, sometimes below 40, sometimes above, maybe 45 one week, 55 the next week. Well, there's ways to do that to minimize your exposure to overtime, and we'll talk and give you an example of that momentarily as well. And the last thing is sort of a combination of all these, but nothing that the Department of Labor's regulation does prevents you from reorganizing if need be. You can reorganize job duties and responsibilities. You can reorganize personnel. And what do I mean by that? So if you've got 3 professional accountants in a department and all of them are currently exempt, but they all make under the minimum required threshold, well, there's nothing that prevents you from only adjusting, maybe promoting one to supervisor of the 3, raising that person's minimum salary to meet the new minimum, and then converting the other to non-exempt, and you can move around job duties so that you can create other positions, in other words. And if you're going to maintain somebody as a non-exempt employee now in their current pay and start paying them overtime, you can move job duties around if need be. So any of those kinds of things you still can do. Again, there's some unintended consequences to doing such things, such as morale of the employees and how you implement it, but you can do it if you decide you need to do it. And those are the kinds of things as we go forward that we'll be talking about evaluating over the next 5.5 months. You don't want to be in a position of making those kinds of changes last minute. All right, so how do you maintain the exemption? Well, let's talk about option number one. That is raising the employee's salary to the new minimum. If they make less than $913 a week, or $47,476 per year, option one is to simply raise their salary so that it meets that minimum. Assuming nothing changes with your job duties and they were otherwise exempt, that's perfectly legal. In order to do that, though, you have to ask a number of questions, obviously. One is, how many people does this affect? So if you don't already have a really good understanding of your workforce and how many exempt employees make under $47,000, that's step one in my mind. We need to go see who's making less than that, what jobs they're doing, how far below the minimum they are. Obviously, if somebody's making $47,300, it's relatively easy to raise their rate by $176 on December 1 and maintain status quo. If somebody's making $30,000 a year and is exempt, most employers are not going to give them a $17,000 raise on December 1 and just to maintain this exemption. Wouldn't make sense operationally. The overtime you're likely to pay is going to be much less than that. But you need to have answers to those questions at your fingertips to make these decisions. As I indicated, I think you also want to look at employees that are making just above this level. If not now, certainly going forward. While this $47,000 amount's not going to change until January 1, 2020, anybody who's making right around there, it is going to change. It's probably going to go up several thousands of dollars. So if you need to project out a few years, if you raise someone only to the minimum, $47,000, or they're just above it, recognize that in 3 years' time, there's going to be another $4,000 or $5,000 jump potentially, and they may get a raise, and you want to make sure that you factor that in so that as you're deciding merit increases and COLAs over the next 2 or 3 years, you don't do that in a vacuum without understanding that they may get another raise January 1, 2020, and every 3 years thereafter. How many hours does the employee work? This is probably one of the most critical things you have to gather at this stage. You need to know, for exempt employees who might be converted to non-exempt, how many hours do they typically work? Now, this is sometimes more difficult than it sounds, because with your exempt employees, as most of you know, you don't have to track their hours each week. Some people do, some don't, but it's not legally required. And if you don't, you need to get an understanding of what they're working. So somebody who's currently exempt but making less than the minimum, but never approaches 40 hours a week, there's not much sense in raising their salary to meet the minimum. For that individual, converting them to non-exempt, making them eligible for overtime may be the best route, because they're never going to get any overtime having never worked over 40 hours. Of course, if something happens in a particular work week, they do work over 40, they would get it. But you need to know how many hours the employee works to do that type of calculation. And most substantially, you have to count the actual hours worked. For these type of employees that we're talking about, it's more difficult than the production level employee typically. That's because executives, professionals, high-level administrators are not necessarily working 9 to 5 set schedules. These are the folks in your firms that are answering the phone on the weekend, sending out emails each night, are on call, they're coming in when need be. Well, those kind of hours, if they're converted to non-exempt, now become actual working time, and you must pay for them. So when I say you have to determine how many hours does the employee work, it's not simply how much are they scheduled for. It's how many hours do they actually work, including all of the off-schedule hours. Now, if you get to the position where you're going to raise people who are close to the 47,000 level up to that 47,476 annual salary so that you can maintain the exemption, one other thing to keep in mind is that you often have numerous employees within the same job classification or doing similar things, and sometimes they're all, if it's easy, they're all paid the same. But the reality is, a lot of times they're not all paid the same. So if you have senior level employees that are close to 47 and you feel like we're going to move those people up to the minimum required as of December 1st, but other people doing similar or same jobs that because they have less years of service or warranted less merit increases make $5,000 less, you have to consider those things. Are you going to raise that person also up to maintain the exemption for everybody in the job class, or are you going to have a job classification where some of the employees are exempt and some aren't, even though they may all do the same job duties? You can have that. That's legal. It's done on a job by job basis and not job classification or job position, but it makes it more difficult to administer and manage those employees when they're doing the same thing. One's exempt and one's not exempt, so you need to consider that. Let's talk now about converting employees to non-exempt status. So if you have an employee, they're making less than $913 per week, and it's just not an option to raise their salary up to $913 per week. Your only other options are to convert that employee to a non-exempt employee. Fortunately, you have a number of options and ways to do that to minimize your overtime exposure. What we want to do now is to walk through each of those options. In order to do that, though, you still have to know a number of things. Like I said, you have to know how many hours the employee is working, including hours that may not be scheduled. You're going to have to, for non-exempt employees, begin tracking the employee's actual work time. There are several ways you can do that. If they work a standard schedule, they don't have to necessarily clock in and out, but they can report any changes to their standard schedule. There are various ways of tracking the time, and we're not going to go through all of those today, but it's key that you actually do start to track the time on a weekly basis and pay overtime where they work more than 40 hours. You're going to run into morale problems with some of these things, as I mentioned. Employees, if you're going to change their salary or wage rate, particularly if you're changing it to reduce it so that their base salary plus expected overtime is equivalent to what they currently earn. We've done that numerous times, and my experience is every single time the employee views that as a demotion. If viewing it as a demotion, it actually isn't a demotion, and frankly, in my view, it's more favorable to the employee because they now do start getting paid overtime, and to the extent most of us who fit the white-collar exemption work well more than are typically scheduled, they may actually earn more, but they will view it as a demotion, at least initially. So we talked earlier about things that you can do now. One of the things you can do now is starting to get that message out. First and foremost, if you haven't already seen it, the announcement today by the Department of Labor and by the President is going to get significant airtime. It's going to get airtime over the next couple of weeks, couple of months, and then it's going to get more airtime as we get close to December 1st. There'll be a lull in between that. But now is the time for morale issues. You can take advantage and, for lack of a better term, blame the government, the federal government, that is. So to the extent that you can decide what you're going to do now, you might want to make those announcements now and put it on the shoulders of the federal government if there's any morale issues, as opposed to doing it in, say, July or August when everybody's forgotten about today's announcement and it looks like you're just giving an employee a demotion in terms of a pay cut. You can obviously take other operational actions like scheduling. Employees that are exempt now and typically work 50 hours a week, let's say, nothing wrong with saying you're now limited to 40 hours a week if, as a reality, a practical matter, you can keep that employee from working only 40 hours a week. You can implement policies that provide you are not allowed to work more than 40 hours a week without advanced approval, and typically you can require employees to get that approval. There is going to be some transition needed for employees, however, that never had to do that before and now are going to have to. So from my perspective, you want to start at least educating employees, implementing those policies over the next few months rather than trying to do it all on December 1, because without fail, you're going to have employees for those first couple of pay periods, maybe even for a couple of months, who continue to do what they did before. In other words, if you make someone non-exempt, you tell them you're now no longer allowed to work more than 40 hours without approval, you'll still see them emailing you on the weekends, at night, doing other things, staying late. And on one hand, you want to encourage that kind of attitude amongst your employees. On the other hand, if they're now non-exempt, you cannot allow that unless you are going to pay for it. So if you need to get the message across to the employee, do it before the effective date. use this transition time to do that, in other words. So let's talk about the actual conversion. How do we do it? If you're going to convert somebody from exempt to non-exempt, easiest way to do it is make them hourly, pay them time and a half for any hour worked over 40. If you don't want to do that, or if because of employee morale issues you want to keep them salary, on the slide in front of you you'll see the easiest way to keep somebody on the salary but still pay them overtime is to call it a minimum salary, but in essence make it an hourly rate. And what do I mean by that? Well, let's look at the example here. Assume an employee earns $1,000 per week in salary. There's nothing wrong with continuing to pay $1,000 per week, and of course my example I should have thought through a little bit more. That would be enough to satisfy the exemption, but assume it actually was too low and this person's non-exempt. You know, paying overtime is a straightforward calculation. The salary is based on a 40-hour work week, which means that individual is actually getting paid $25 per hour, whether they realize it or not. Whether you call it a salary or you don't call it a salary, it's $25 per hour at $1,000, and you have to pay that person. If, say, assume they work 50 hours one week, then they get their minimum salary of $1,000, but on top of that you have to pay them $375 in overtime. How do you get that number? It's simply the $25 an hour regular rate, time and a half for 10 hours, which is the 10 hours over 40 worked that week. If it were 5 hours, they only worked 45 hours that week, you would get 5 hours at time and a half, $25. So in other words, as you can readily see from this, even though you're calling this person a salaried worker, in essence they're an hourly worker making $25 an hour with a minimum guarantee, meaning if they're lower than 40, you're still going to pay the $1,000. So, you know, the pros and cons for this one. The con is, or the pro is that it may save you in some employee morale if they're already making a guaranteed salary and you keep it the same, start paying overtime. You know, they're not going to sense a change and they're going to get extra overtime. The obvious downside is they get that extra overtime. The extra overtime is pretty substantial because it's at a time and a half rate for all hours worked over 40, and you're essentially just giving them a minimum guarantee. So if they only work part of the week, then you're still giving them the full salary. So, you know, this is an option for a few employers, but primarily it's employers with money to burn. It's not one we typically recommend. If you're going to go this route, just make them an hourly worker, and this way if they only work 30 or 25 hours in a given week, you don't have to pay the full salary. But there are other ways of doing this that might work for your particular situation. So first, you can pay a salary based upon the employee's typical schedule. So here again, if you have an employee and you know that they typically work 50 hours, now they're going to be converted to non-exempt, so you're going to have to pay an overtime component. You can base your salary on the schedule instead of on the 40-hour work week. So how does that work? Well, let's talk about an example, again using someone making $1,000 per week and say working 55 hours in a given week. The employee must be paid his base salary, $1,000, and ultimately, as you'll see, he's going to end up getting paid another $250 on top of that if he works 55 hours. Now, how do we get to that number? Well, the key here is that the $1,000 salary is divided by the number of hours that it's meant to compensate for, i.e. 50. $1,000 divided by 50 is 20. If my math's right, is $20. Regular rate is now $20 an hour. And here's the other kicker to this. For that first 10 hours of overtime from hours 40 to 50, he only gets half time. So instead of $20 of a regular rate at time and a half, he gets half time, which is $10 at 10 hours. The reason for that is that the salary is meant to compensate him for all straight time work that he does up to 50. So the straight time component of the time and a half calculation has already been paid. All that is left to pay is the overtime part of half time. Now, of course, since this guy worked 55 hours that week, any hours over 50 still have to be time and a half his regular rate. The regular rate being $20 an hour. Time and a half is 30. For those extra 5 hours, he gets another $150. So it's a little bit more of an involved calculation, but something that can diminish the salary. And this is best used for employees that are being converted to non-exempt status who have a pretty set schedule that exceeds 40 hours in a week. You still have to pay overtime, but the overtime, as you can see here, you're only paying $1,250 in overtime for somebody that worked 55 hours. The prior example, when you pegged the salary at 40 hours, had somebody getting paid $1,375 for only 50 hours a week. So it's more hours worked by this particular employee, less overtime liability. Now, if you're going to use this as an option, you really need to have some sort of written documentation as to how many hours the salary is meant to compensate for. It's not legally required that you have it in writing, but we recommend it, and we recommend you get it signed by the employee, because what happens is employees, when they sue you, if they want to sue you after the fact, say, no, we never had an understanding as to how many hours my salary was meant to compensate for. Now keep in mind, this is not a method to get around overtime. You still have to pay an overtime supplement for any hour worked over 40. It just allows you to pay half time for those hours where the straight time is already built into the salary. You also need to be very careful anytime you pay a non-exempt employee a minimum salary. If you're going to take advantage of these things, and the next one, the fluctuating work week that we'll talk about, this applies equally. You have to be careful with deductions. If you start to deduct from the salary, the Department of Labor is going to take the position that you're really not paying a minimum guaranteed salary. You cannot take advantage of this, and they'll consider an hourly worker that is entitled to time and a half for all hours over 40. The examples with exempt employees that you may be familiar with in terms of when you can make deductions and when you can't, the deductions that we're talking about for these type of non-exempt employees are more strict. So you want to be very careful if you're going to implement these things anytime you're taking any deductions from the minimum salary. For that, certainly if you're considering that and you want to set up policies to that effect, that's something where you ought to talk to one of the attorneys here at Allen Norton Blue to make sure once you have that in place that it's compliant with the law. Now let's talk about the next way of doing it. This is what's commonly referred to as the fluctuating work week method. It's essentially the same method we just covered, except this is for employees whose hours worked on a given week fluctuates. Sometimes it's 30, sometimes it's 40, next week it's 50, 55. So here I've provided two examples for you. Again, assuming employee makes $1,000 per week, which again I understand is more than the minimum for the exemption. Ignore that for now. I use that just as a round number. But assuming that this same employee now is making $1,000 per week in guaranteed salary, and we tell this employee, your minimum guaranteed salary is for all hours you work. No matter the number, all hours you work any given week, that's what your salary is meant to pay for. And that's the straight time component, not the overtime component. Well, let's assume now that during week 1 the employee works 50 hours. Well, the employee here is entitled to a weekly salary of $1,000 plus now he needs the extra overtime component, which you'll see equates to $100. How do we get to that $100 number? Well, here every single work week you have to take the minimum salary and divide it by the hours he works that week. So here if he worked 50 hours that week, 1,000 divided by 50 is $20. That's his regular rate. You then give the employee overtime for all hours worked over 40, but it's at the halftime rate. So here if his regular rate's $20 an hour, he gets $10 for all hours over 40. That's 10 hours and $100. So in this particular example, this individual works 50 hours and only gets $1,100. You can already readily see the advantage here when you compare it to our prior examples. This employee is working the same amount of hours as those prior examples and getting paid a lot less than the first example, which had $1,375, or the one we just reviewed. Now, what happens in week 2? What's the downside to this method? Again, assuming your employee's hours fluctuate, you can use this method, but the downside is it's administratively difficult because you have to calculate the regular rate every single week. So here, assume week 2, now the employee's not, instead of working 50 hours, he's worked 55 hours. Well, you take the $1,000, you divide it now by 55 to come up with the regular rate. That comes to $18.18 an hour rounded. Again, you only have to pay halftime for all hours over 40. So here you take that 1818, divide by 2, pay the halftime, which is $9.09 an hour for the 15 hours. It's $136.35 extra that the employee gets in overtime compensation. So for that week too, he gets $1,136.35. The advantage to this is that the more hours the individual works, the less that they're going to earn. So it's a definite disincentive for employees to try and milk the clock. At some point in time, they're going to be earning very little on an hourly rate. The downside, as I mentioned, is the administrative headache that you have to go through, and your payroll office might revolt having to do this calculation every week, but it is doable. You can set up spreadsheets and payroll programs to do it. Here again, you need to have written documentation. It's not required by law to be in writing, but it's certainly guaranteed. It's required that the employee and employer have an understanding as to this method before you employ it. And in order to have the understanding, we recommend it be in writing and acknowledged and signed by the employee. Again, you've got to be careful with deductions from the salary, as any deductions can be seen by the Department of Labor as essentially a hybrid plan trying to obtain the benefits of the fluctuating workweek method without the downside of the minimum guarantee that an hourly worker has. All right, now here's the other method that a lot of employers, I think, are going to end up taking. For those employees where it's just not a reality to raise their salary up to $913 a week, what can you do? Well, the short answer, if you don't want to raise them up and you don't want to just start paying them overtime, is you can lower their salary. So this is for employees where it's not practical to raise their salary, but it's also not practical to limit them to 40 and you don't want to just start paying overtime. So I use the example here, assuming you had an employee making $800 a week and at 50 hours in a typical week, you know, they're essentially making $16 an hour and their minimum salary is $41,600. Assuming you don't want to raise them up to $47,000 and give them an instant raise, if you did nothing other than convert them to non-exempt and they work 50 hours a week, they're going to be entitled to $880 a week at a salary set with $800 under the expectation that it's for $50. So that employee, if you did nothing else other than convert them from exempt to non-exempt and allowed them to continue working 50 hours, they're going to get $45,760. So you just gave them a $4,000 raise, albeit it's not the $6,000 or $7,000 raise that the Department of Labor would love you to give them to keep them exempt, but it's still a significant raise. So what's your option? Well, your option is you can work the equation backwards, and nothing prevents you from lowering that individual's hourly rate from $16 an hour, essentially. And I did this calculation already, but we can certainly assist with it. If you lowered that individual's hourly rate to $14.55 an hour, then they essentially end up with $800 per week in salary. And that's with the overtime built in. That's with 10 hours every week of overtime. So that employee goes from making essentially $16 an hour to $14.55 an hour, and they are maintaining their consistent salary. Now, what does that mean from a morale standpoint? Well, if you're doing this, I'm doing it on an hourly basis, but if you $14.55 an hour equates to $30,264 for a full-time employee on an annual basis. So you would be going in and having this conversation with the employee. You would be telling the employee you're going to go from making $41,600 a year with no overtime entitlement to making $30,264 a year, but we're now going to pay you overtime, and since you always work 10 hours a week in overtime, it's going to come out to $41,600 a year. The employee is probably going to be suspicious of that and realize, and their first reaction is going to be, you just gave me an $11,000 demotion. So here's a key point to today's webinar. If you're going to do this, what I encourage you to do is use this next 5 months to implement it, not to implement it, but to use what I call a comparison. So what do I mean by that? Well, there's nothing that prevents you from continuing to pay that employee $800 a week between now and December 1 when the new change goes into effect. And then as of December 1, you're going to lower the wage rate But what I've done in the past with good success, quite frankly, was when we made a change like that, we included within their pay stub each pay period a printout of the current pay at the current rates, and then also a printout of what it would have been had we reduced the salary to the rates that's going to be reduced on December 1. And of course added the overtime to that. That does require that you start to ballpark and you start to look at the overtime that they're working now. But if you can show over the next few months that the employee is not going to be harmed, while they'll still be getting paid their base salary with no overtime, but you include a comparison of how it would have worked with the lower salary plus overtime, it does two things. One, it convinces the employee, hopefully, that the change in wage rate when you add the overtime isn't really harming them. And two, it allows you to look at those calculations, even if you don't share them with the employee. If you decide that's not a good idea, do them anyway if you're going to lower someone's wage rate, and make sure that it actually doesn't harm the employee if that's not your intent. So what do I mean by that? If over the next 5.5 months, as you start to look at what this employee would be making if they were getting overtime, if it turns out that they're not working the hours that you thought they were and they are going to end up earning more or earning less, then you now have 5.5 months to play with the wage rate and or the employee's schedule and how much you're going to allow them to work, so that on December 1 you don't have a lot of assumptions, and then you get into January 1, February 1 of the next year, and it turns out a lot of these assumptions about how many hours they worked, those kinds of things were wrong. You don't want to do it while you're actually paying the employees, because it's going to be real dollars you're playing with at that point. There's nothing that prevents you from looking at that now and running a couple of these scenarios, whether you share it with the employee or not. I think it makes some sense for a lot of these employees to share it with them, because it'll help with the morale issue. But at a minimum, I would be doing these kinds of things from the payroll side and looking at it so that when you get to December 1, you can decide which of these types of systems and converting an exempt employee to non-exempt best fits each job category, each person. Are you going to do things like reduce hours over time? Are you going to reorganize employees, like mentioned earlier? Or if you reduce hours, are you going to need to hire more workers? There's nothing that prevents you from looking at those things and sort of testing some assumptions between now and December 1. And those are the kinds of things, in addition to gathering the information you'll need and making decisions, I think you ought to be doing over the next 6 months. Policies, you want to be looking at between now and then. Policies, do you need to implement new policies? You need to implement policies for tracking hours worked. Do you need to implement a policy that prohibits exempt employees, or excuse me, non-exempt employees from working more than 40 without approval? If you convert a whole bunch of employees from exempt to non-exempt, I expect that you'll see that the knee-jerk reaction by a lot of those employees is to continue to work the same schedule that they previously worked. And if you don't want them incurring overtime, you may need to start to implement those policies now if you don't already have them. Do you need to look at things like whether you allow a formerly exempt employee who's now non-exempt access to emails, your networks, your databases, things of that nature from home? What about company mobile devices, things of that nature? If you want to limit the amount of hours they're working, you got to look at that now, and you may have to supplement and modify policies. For those of you that deal with unions, you're talking about, if any of these folks that we're talking about are exempt and going to be converted to non-exempt are in a bargaining unit, well, you're making a change to their pay rates, and your pay rates may force changes to other things like scheduling, things of that nature. Those are mandatory subjects of bargaining. You don't want to be in position on November 30th of announcing changes if you've not disclosed those to the bargaining unit. While you will still have to comply with the FLSA and these new regulations, you might subject yourselves to unfair labor practices. So you need to look at that now and maybe start to make these decisions and advise the union, and if they request bargaining, to bargain. One thing you should do is consider whether or not you want to involve your attorneys. Here again, it's a simple regulation. We're changing the minimum salary from $455 to $913 a week, adjusting it every 3 years. But these questions, as you can see, as to how you pay a non-exempt employee that's higher level than your typical hourly, and all the attendant responsibilities that flow with that. There are a lot of potholes, and unfortunately Florida, along with California and a few other states, we're seeing FLSA lawsuits all over the place. So there are attorneys just out there at the waiting to start and sue over every misstep you make. For those that don't know, the first wave of these FLSA lawsuits began after the last round of rule changes in 2004. And I think part of that was because of the airplay that those rule changes engendered. And here I think you're going to have the same. So there's going to be probably a wave, an increased wave of wage and hour lawsuits. If you involve your attorneys and you start looking at these things and having audits done, one benefit that you have, and this, whether you have in-house attorneys or outside attorneys, is some of your communications and your deliberative processes are now going to be privileged, and you can have some frank discussions maybe you wouldn't otherwise have. And if there are risks, you can talk openly about them without it becoming evidence against you in a subsequent lawsuit. I just want to finish up today's webinar with a couple of things that we recommend you don't do. Obviously, as we've been talking, do not just stick your head in the sand until December 1 and hope it all goes away. As I said, the rule was announced this morning at 8:45 this morning. It was sent to the Federal Register. The publication is coming out next week. If you want a copy of the rule, by the way, you can get it, even though it's not yet published. It is online. So it's going to happen, and there are things that you can do now. Everything from blaming the federal government for anticipated changes down the road to running some mock audits and doing some of these different calculations if you're going to convert to non-exempt and seeing which one works best before you start to work with real money, so to speak. What else do you don't want to do? Well, unfortunately, I think from history, the last time that the salary level was raised, one of the knee-jerk reactions we saw a lot of employers do was to convert employees to independent contractors. This is a very hot topic with the Department of Labor the last couple of years. The short of it is, don't do it. An independent contractor is not an independent contractor just by virtue of being named one. There are strict tests. The FLSA has the most restrictive definition of independent contractor of any employment law. So here, if it's somebody that's truly an independent contractor currently, there's no change to that. They don't need to be reclassified as an employee on December 1st. But the same holds true for the opposite, and that is somebody who's an employee now, don't convert them to an independent contractor between now and December 1 and not pay overtime. The employees, the Department of Labor, probably the IRS, and certainly plaintiffs' lawyers will see right through that, and all you're going to do is get sued. Also, don't just assume that these newly non-exempt employees only work 40 hours. Again, I can't stress this enough. These are usually higher level or more professional employees that we're talking about that might get converted to non-exempt employees. To the extent they're not used to only working during their regularly scheduled hours, they're not going to do that overnight. So you're going to need to have oversight of that. In addition to any policies and practices, the employer is not allowed to turn its head the other way and allow employees to work off the clock, even if you have a policy that says it requires approval. You certainly can have that policy, and if you don't know that they're working off the clock, you should be fine. But if you do have knowledge that employees are working off the clock, or you should have knowledge, then you are liable to pay for it. Department of Labor's position is you have to stop that employee. If you know it's happening, stop the employee up to possible discipline and discharge if need be. So don't just assume that overnight employees that regularly answer your emails, make phone calls, come in on their off time are going to stop that. If you want them to continue doing that, you can certainly allow it. You just got to pay for it if they're non-exempt. Also, of course, don't assume that all employees who make over the minimum salary, so assuming you have someone making over $47,000, don't assume that they're otherwise exempt from overtime. Keep in mind that you still have that job duties test that we mentioned at the outset. It must be satisfied. There's no change in that. That's the way the current law reads as well. But it should be a little easier with these higher level employees. Anybody getting paid $47,000, more likely that they satisfy the job duties test, but it's still there and you still have to satisfy it. Lastly, I'd say if you're going to raise somebody's salary to the new exempt amount, don't then turn around and try and undo it with impermissible deductions. The deduction rules have not changed with this new rule, so with a salaried exempt employee, you only can deduct in certain limited circumstances. I'm not going to get into that here. It's different for private and public sector, but suffice to say, don't raise a salary and then try and undo it with improper deductions. And if you do convert someone to non-exempt but choose one of the salary methods of paying, also be very wary of deductions, because those apply and in fact are stricter for those employees. That concludes our webinar this afternoon. We are putting together a client alert fact sheet which covers some of these changes, and we should have that emailed out to you, if not today, tomorrow. Also, today's webinar was recorded. There was substantial interest in it. In fact, more than the webinar could accommodate. So if you know of anybody who was unable to register or unable to watch the webinar live, let them know that there are going to be recordings available probably within the next day. And if anybody wants to go back and review it with anybody else, there should be an email sent out to all attendees with links and instructions on how to access the recorded webinar within the next couple of days. Lastly, contact anybody at Allen Norton Blue. You certainly can contact me in the Tampa office, but don't feel compelled to contact me. You can contact anybody, any of our attorneys at any of the 4 offices on the screen in front of you. Should have the phone numbers. You can also email. If you don't know who to contact, certainly contact me or call any of these numbers and we can help you with any questions or concerns. Thank you for attending today's webinar. Have a good day.